All right, well, we're here on July 19th, 2016 with Mike Putnam, who's one of our oral history participants in the Federal Magistrate Judge Association Oral History Project. And we're just trying to capture people's thoughts and reflections about this job and about your path to the judgeship and any thoughts you might have for the next generation who's coming behind us. And so why don't you just start, first of all, just tell us a little bit about your background and where you grew up and what your family life was like.
I was born in Albany, Georgia. My father was in the Air Force, so we moved around quite a bit. I like to say that my older brother was born in Honolulu, Hawaii. My sister was born in Panama City, Florida, but I got stuck with Albany, Georgia. So, moved to Alabama when I was 6 years old. That was my father's home. He actually grew up in Alabama, so I consider myself an Alabamian. Went to the University of Alabama undergraduate school, graduated in 1976, a degree in political science. Went to the law school there at the University of Alabama, graduated in 1979. Then started practicing law in a little town in northwest Alabama called Florence, Alabama. I grew up in Phoenix City, which was, you may know, is notoriously a sin city, but grew up in Phoenix City and then went to Florence to start practicing law.
But tell me why you decided to go to law school.
Well, it's both simple and complicated at the same time. The simple story that I tell my children is that I was, in the fall of my senior year as an undergraduate, I was sitting on the steps of the library trying to figure out, okay, what do I do now? And it came down to either pursuing a graduate degree in history or going to law school. And so I decided to go to law school because I had spent several years in undergraduate school studying political science and particularly studying political theory and philosophy. And I liked the idea that law sort of is the moral code for society at large. People have their individual personal moral codes, religious codes, whatever it may be, but as a society, as a large community, law is the moral code. And so that interested me about what is the balance between using law as a way to order things, but in the same way as, but maintaining or preserving freedom. It's sort of the odd paradox of law that it imposes rules of order, but it does so in a way that preserves freedom for us.
This was pretty deep thoughts for a 22-year-old.
Well, as I say, I mean, I had studied philosophy in undergraduate school, so I like to fancy myself as at that time as having profound thoughts. But it had more to do, I think, with the warm autumn sunshine, sitting there, just trying to figure out where does my life go from here. And so I ended up taking the LSAT and applying to law school and being lucky enough to get into law school. So that's where I went. And I'm glad I did. I mean, law fascinates me now. It fascinated me then, 40 years ago. And I couldn't have asked for a better professional career than being in the law. I've loved every minute of it.
And I think a lot of our members certainly reflect that and are dedicated to advancing the law and respecting the law and fostering respect for the law.
It's a civilizing effect, and you know, I tell people when I start talking about lawyers generally, I said, you know, lawyers are sort of like the lubricant that allows the gears of society to turn without undue grinding. You know, if it weren't for lawyers as problem solvers, however that problem is solved, whether it's by mediation or litigation or whatever, but lawyers are the problem solvers. So I like to think of lawyers and the law generally, lawyers more so, as being the lubricant that allows the gears of society to grind away without coming to a halt. And law is the thing that unifies all of us. It's the set of rules, it's the set of understandings that we all have as a civilized society. And so I try to, I've always had an immense amount of respect for the concept of law, even though there are perhaps individual laws that I don't particularly like. But the concept of law as a unifying force in society is something that's always sort of fascinated me, and I have a lot of respect for it.
So what kind of practice did you either seek out or did you find?
Started in a small firm. I was recruited out of law school by the big firms, as we refer to them in Alabama, in Birmingham, and being a small country kid from Phoenix City, I just really didn't see myself fitting into the big law firms there in Birmingham. So I took an offer from a small 5-man law firm in Florence and moved to Florence, Alabama, and started there in just sort of a general law practice.
Mm-hmm.
I tell the story that I graduated from law school in June. I took the bar exam in July. I tried my first case in August, and I got my bar results in September. So, and that you can do something like that in a small town in Alabama, but you can't do it anywhere else. I mean, but I had just sort of a general practice, and in the beginning, it started out mainly as being representing plaintiffs, ordinary people, and I enjoyed that. It's a lot more challenging than just the legal questions that arise. In representing ordinary people, everyday people with their problems. I came to understand that phrase of being an attorney and counselor at law, that the counselor part of it really does come into play. You're expected not to just solve somebody's legal problems, but to help them with their marriage problems and their children problems and all sorts of problems as an attorney. So I did that for several years, and then eventually, and I frankly don't know how it happened, but just sort of evolved from there over to representing mainly 2 clients toward the end of my practice before being appointed to the magistrate judge position. I represented the University of North Alabama, a little small 4-year college there in Florence, and Humana Hospital. So anytime hospitals got sued, or the university fired somebody, a professor, and they got sued, I was representing them.
Those were good clients to have.
Pretty good clients.
Great.
Right there at the end was pretty good, yeah.
So how long were you so you stayed at the same firm?
Stayed at the same firm, initially as an associate, and then became a partner
and what
after
was the
3
name
years.
of the firm?
It was Potts, Young, and Blassingame. It eventually became Potts, Young, Blassingame, and Putnam. I told them, you know, I'd be happy to have my name left off the firm name if you just pay me more money, but they decided to put my name on the firm name. So, but
I mean, you mentioned you became a partner after about 3 years, and again, I think that's another advantage of a smaller town county seat practice is that if you're doing good work, you'll be rewarded, and
if you fit in and everybody likes you, and it looks like the personalities don't unduly clash, and you're doing decent work, yeah, I mean, you can progress a lot more quickly in a small town practice like that.
So how long were you with the firm?
Almost 10 years.
All right.
And then in early 87, was appointed to be a magistrate judge and moved back to Birmingham at that point, to my duty station being in Birmingham, which is about, I don't know, 120, 125 miles from Florence.
So how did you even know that there was such a thing as a magistrate judge, or at that time it was a magistrate, but how did you become aware of this particular class of judge in the federal system? And like, had you applied to be a state court judge, or what was your interest in the judicial career?
I had always been interested in a judicial position. I guess principally because I view the judicial position as being more difficult than the lawyer's position in the legal process. And I think for the obvious reason, it seems to me, that the role of a lawyer in representing a client is defined by the client's interest. What arguments you make, what cases you cite, all are directed toward advancing the client's interest. And so that makes your marching orders, so to speak, easy to identify. But being a judge requires you to make the right decision, not just one that's necessarily favorable to a particular position in a case, but making the right decision, finding the right answer. And that idea of trying to find, taking a problem and trying to arrive at the correct solution to the problem was something that interested me. And frankly, for the magistrate judge position, I think the way I became familiar with it, with the position, was I was just looking through the State Bar magazine one day and saw a notice, of their applications for magistrate judges, and I thought, well, that's interesting. So I put in an application and went from there.
So did you have a significant federal court practice, or had?
Yeah, at that point in time, principally because of representing the university in 1983 actions, getting sued all the time by college professors. I had a great deal of experience in federal court and enjoyed federal court practice better than state court practice. The formality of it, the integrity of it, and in Alabama, and this is not true across the board of everybody in Alabama, but when in Alabama, if you're going to litigate in a small county court somewhere, you don't know exactly what all's going on behind the scenes. So, and that always bothered me about the integrity of the system. And the federal court system, I never had those questions. I always knew where I stood, where everybody else stood. And so I enjoyed that about federal court practice, and that's why I tried to focus in federal court practice.
So what was the selection process? Obviously, there was a merit selection committee that
Right.
is comprised of lawyers and non-lawyers, and they screen. And so you went through that application process?
Right. Put in an application, went through, got called for an interview, which was a surprise to me. Got called for an interview. I really didn't know who else the committee was considering at that point, but I remember one of the lawyers on the committee asking, sort of an obvious question, well, why do you think that you would be the best candidate to be selected as a magistrate judge? And the answer I gave was, well, I don't know how to answer that because I don't know who else is being considered. I may or may not be the best person here, but I can tell you that I will work hard. I will apply everything, all the skill and knowledge, experience that I have, and I'll give you everything I have. But whether that's good enough to be better than the other candidates, I can't tell you. And apparently somebody was taken with that answer, apparently.
Well, I think having trial experience, that's certainly the model of a judge, like in the era that we grew up, that you did a lot of trial work, and that's how you measured yourself against the judges on the bench, and that's how other lawyers knew what your skill set was.
Mm-hmm.
And now today that we're not trying so many cases, I'm not sure how lawyers demonstrate.
And I think that's right, because when I was selected in '87, I had actually tried cases in front of probably 2/3 of the federal district judges there in the district at the time. They knew me. They had tried cases with me. How young lawyers these days get known to the judges is, a mystery to me now, because not only are there fewer trials, far fewer trials, there are just far fewer instances of actual personal contact
Right.
between the judges of a court and the lawyers. Everything's done by email and filings and telephone calls. And I just think it's a much less personal experience than it was when I started years ago, where you routinely went to conferences with district judges, you routinely appeared at motion dockets every month or so. You were in federal court a lot.
Well, and clients would pay for you to bring an associate, and you could actually mentor and bring someone
Right.
along in the practice, and now clients are looking over the bill and they're only letting one lawyer do
Right.
things.
Right.
And I don't think firms can support the kind of development of younger lawyers and giving them some opportunities that we had, like being handed a file on your first day at work before you've passed the bar.
That's right. Go try this case. Oh, okay.
Okay. You know, and again, I mean, there's positives and negatives to that, but I think that the culture of the bar loses some of the demonstration of professionalism and problem solving, and when you're just dealing with emails, it's too easy to be snappy and
It is so much, there is so much more civility, I think. And we talk about civility all the time, but there is so much more civility in face-to-face conferences, even compared to telephone calls.
right.
There is so much more, and so that's one of the things that I try to do as a magistrate judge. And you know, I sometimes wonder whether I'm imposing on the lawyers too much by holding conferences in chambers. Come up to the courthouse. Let's sit down around a table and talk.
I worry about expense.
I worry about that, but I think it adds an element of civility to the case. I think it enables lawyers to get to know me, and I get to know them. One of the things, and I tell other magistrate judges this, you know, one of the reasons that I have conferences, in-person conferences, is so that lawyers can come in and see me, the magistrate judge, who is asking them for their consent in a case to see that I don't have a tail and hooves. So they can come in, they get to know me. It eases the consent process some. It increases the level of civility among the lawyers, I think.
I do.
There may be an expense and a burden entailed with it, but I think the benefits offset it.
So when you got this position and moved, at that time, did you have a family?
I did. My wife was pregnant. We'd been married about 3 years, and I was appointed in February of 1987. My wife was pregnant. Our first child was born in August of 1987, and our anniversary just happened to fall on August 20th, and my wife was literally about to burst pregnant. And I made the mistake, young judge mistake, I scheduled a suppression hearing for 3 o'clock that afternoon.
What were you thinking?
Well, I don't know what I was thinking, but I thought, you know, suppression hearing won't last a couple of hours. Scheduled a suppression hearing at 3 o'clock and told my wife, just come on down to the courthouse at 5 and we'll go to an anniversary dinner. So she comes down there. We start at 3. She comes down at 5. And finally, at 9 o'clock that night, the suppression hearing, it finally wraps up. I can remember the defense attorney, it was a case of a defendant charged with stealing property from the Tennessee Valley Authority. He worked for the TVA, and he would just go in and take things out of their warehouse. And there were 77 photographs of things that he had stolen. And the defense attorney went through that stack of photographs with the FBI agent 3 complete times. As we sat there, my poor wife was about to cry, sitting on the benches in the courtroom, thinking, "Oh, we've missed our reservation for dinner." And so after we finally get out of the suppression hearing, we go to the restaurant where had reservations like 2 hours earlier, and they're about to close up, and my wife breaks down and starts crying, and they opened the kitchen and just gave us dinner there. So it was wonderful.
And what did we learn from that?
Schedule suppression hearings at 9 in the morning. If you're going to go with it, go all day long. And if you finish early, then it's just gravy at that point.
So what's the variety of duties that you have or have had in your tenure?
It's changed a lot from the beginning. In 1987, magistrate judges in the Northern District of Alabama did mainly prisoner things. We
Right.
did 1983 conditions cases and habeas cases, all on report and recommendations. We had our preliminary criminal matters, search warrants, arrest warrants, initial appearances, things like that. And the only civil things that we did, civil cases that we did, were discovery motions referred by district judges on an ad hoc kind of basis. So very little. I spent 85, 90% of my time with prisoner litigation in some sort of way.
And did you have a good consent record there, or
no? We
were
would.
those all
When
on
I first
report
started in
recommendation?
'87, our district judges had not designated us for consent jurisdiction. All we could do was report and recommendations. Now, the story was, now the chief judge never told me this, but the story was that the chief judge was concerned that if he gave us consent jurisdiction, that would interfere with our ability to move criminal cases. At the time, the Northern District was the #1 district in about speed of disposition of criminal cases, and he was real proud of that we moved criminal cases very fast. And he was afraid that if he gave us consent jurisdiction, it would interfere with that and slow it down. So from '87 to 1996, it was '96 when I first was finally able to persuade the chief judge to experiment with letting us take consent cases, as many as perhaps 3 a year.
Whoa,
Get 3 consent
wow.
cases a year. So that's when it started in 1996 in the Northern District. So
Plus, you have to get the bar used to that idea.
True.
Because if they've never seen you try cases, and it's been a decade since you tried cases, you have to ramp up too. So
Right.
part of it's the bar culture, in addition to your district judge support. So how did you get the bar on board?
it's been a long, slow process. I mean, like I say, we started in '96 with being given up to 3 consent cases a year. As circumstances happen, of course, from '96 to '98, we had a shortage of district judges. We had several take senior status, we had one pass away, and suddenly the district judges, realizing that their caseloads have gone through the roof, looking around and saying, well, you know, what can we do? And they were much more open to the idea of sharing work, civil work, with magistrate judges at that point. So we wrote in 1998, we wrote for the first time a comprehensive general order giving magistrate judges consent jurisdiction. It was a little cumbersome still, a lot cumbersome still. We were given case assignments off the wheel.
All right.
As cases came in, and if we were able to get consent from the parties, then great. If we were not, then we were to manage the case through discovery and up to the point of a dispositive motion of some sort. And even on the dispositive motion, go ahead and get briefing and write an R&R on
right.
that, which of course then immediately goes to the district judge, and it starts all over again with the district judge. But we did that for several years, and consent slowly began to become a reality. You're right that the culture of the bar was such that they were very reluctant
Right.
to give consent jurisdiction in the first years of it. And, you know, while it was a judicial duplication of work for me to write an R&R on a summary judgment motion only to have it go to a district judge, at least in that R&R, I could demonstrate to the lawyers
Right.
that I'm not a knucklehead, that I know what I'm doing, that I can give you a quality judicial decision. And so that process over the next 10 years or so slowly began to make the bar more open to the idea of consent jurisdiction. And then in beginning January of 2015, just a year and a half ago, we completely revamped the consent jurisdiction general order so that magistrate judges are fully on the wheel for civil cases. We get the same rotation of assignment of cases as district judges, and lawyers then are given a relatively short period of time to say you either consent or you don't consent. Right. And if they consent during that time, then we keep the case. Coupled with that, our now Chief Judge, Judge Bowdry, Karen Bowdry, to her credit, went on, and I sort of jokingly refer to it as the dog and pony show, where we literally, she and a magistrate judge would go law firm to law firm to law firm to law firm.
That was
explaining consent jurisdiction, explaining why the court had confidence in the magistrate judges, telling the law firms who the magistrate judges are. And our consent rates now are somewhere between 60 and 65%.
That's great, but that was above and beyond the call.
I mean, I have to give Judge Bowdry
Right.
complete credit. She spent probably 6 months, maybe 2 or 3 times a week, going to different law firms with a magistrate judge and presenting a program about consent jurisdiction and stressing how the court, the district judges had full confidence in the magistrate judges. And I mean, she went above and beyond the call of duty.
But how do you stay current? If you're on the draw for a full share of the caseload and you only have one law clerk, how do you stay on top of your civil plus your criminal?
Most of us, most of the magistrates, in fact, I think only one magistrate judge still has a secretary. Basically, we have all converted our secretarial positions to a second law clerk, is what it amounts to. We also have, for handling the 1983 prisoner conditions case, now we have also over the last 10 years or so developed a pro se unit. We have 4 lawyers down there who do most of the work now on 1983 prisoner cases, although all of them still come through a magistrate judge. They're all assigned, the consent cases are dual assigned to a district judge and a magistrate judge. And of course, the district judge expects us to make sure that what's done is right. And so,
well, that's good.
So, I mean, if you count those 4 pro se attorneys doing the prisoner stuff, that's kind of like another law clerk. There are 5 magistrate judges in our district, 4 in Birmingham and 1 in Huntsville. So having that pro se staff is almost like having another law clerk.
Well, and for a kind of a high needs caseload where you're reading handwriting and you're trying to decipher what the claim really is.
Right.
Did they really mean to make it a habeas? And
so, you have to go back and forth with the prisoner 2 or 3 times to say, you know, is this what you're saying? And if that's not right, tell me and file an amendment. And you know, that laborious process of just trying to identify what the prisoner's talking about before you can ever then proceed to try to resolve it. Takes a goodly amount of time, and luckily the pro se staff does most of that.
Well, and they develop an expertise in who the cast of characters are and the nature of the claims. And so if they're coming in waves, like we'll have dental waves, or this year seems to be hepatitis C.
Right. You sort of have a claim du jour that comes through every now.
But they can help organize that and, you know, get those cases pulled together.
Right.
So, have you retired? What are you doing?
No, I'm still a magistrate judge.
Still
I'm in my 4th term. I'm 62, so I've got 3 more years to go.
Yeah, plenty of time.
Yeah, I've got 3. So, but I'm anticipating retiring in June of 19. So, I'm looking forward to being invited to a retirement seminar. I want to go to one of those I keep hearing about.
They are great, and you need to go a couple times before it all sinks in. I can tell you from personal experience that there's a lot of information. So what would you tell somebody to encourage them to take this job? And then what would you tell people about things you wish someone would have told you at the beginning?
Well, I guess starting with the negative part of it, there is still this sort of institutional hierarchy between Article III judges, and I don't want to say condescension or they're patronizing about it, but there certainly is, in many instances, the Article III judges are quick to remind you that you are not an Article III judge.
That's right.
And, you know, when you go to judicial conferences, the 11th Circuit judicial conferences, I can remember the very first year I went to one in 1987. Magistrate judges were invited to attend as guests. We even had a separate colored name tag than the Article III judges.
Yes.
Now, luckily, that's gone by the boards now. But I can remember back in 1987, you know, all the district judges and circuit judges all having their white name tags, and I have a blue one because, you know, I'm not suddenly, somehow I'm not a full-fledged member. That sort of hierarchical division still in our court crops up in the form of court governance differences. For many years, I was the chief magistrate judge from 96 to 2003, I think it was. And during that period of time, I was successful in getting the district judges to let me attend the judges' meetings. I didn't have a vote. They would occasionally ask me what I thought about something, and I would speak at but you know, I at least got to attend the district judges' weekly meetings. So I knew what was going on. I had the ability to sort of head off things that might not be good for magistrate judges by being at those meetings. But we've had recently, in the last 5 years or so, we've backtracked from that. Our magistrate judges in our district are no longer invited to attend the judges' meetings. And so I'm very disappointed in that. We had made a lot of progress in trying to get directly involved in court governance, and we've sort of backtracked from that. So that kind of divide between Article III judges and magistrate judges is a disappointing part of it. I told a district judge, you know, maybe I shouldn't have, but I said, you know, I told a district judge, I recognize that y'all are institutionally superior to me, but I will never acknowledge that any of you are personally or professionally superior to me.
Well, I always remind them that I was appointed on merit.
Right.
And then they usually kind of laugh about that.
Right.
Say, oh, okay.
Right.
Right. But sometimes you have to point out, you know, we've been around the block a couple times. We have some thoughts on this, and you're not thinking about how this permeates or impacts from the, you know, intake through the system. And, you know, they're thinking about one little slice of something that perhaps their law clerk told them, who might not really see the big picture.
You know, and district judges seem to me to be so concerned with case assignments and am I getting more cases than the other guy down the hall is getting, and they seem to me to be too concerned with that sort of minutia than just trying to make the court work.
Right.
And so that bothers me a little bit. But on the whole, and I have no apologies for saying this, I have enjoyed every day that I've been a magistrate judge. Even on bad days, I've enjoyed being a magistrate judge. It's the intellectual challenge of it, the reward of seeing something that I respect, the law, develop over time, the frustration of seeing some areas of the law sort of hamstrung and not developing the way they should. But all of that, being intimately involved in that process, is something that I find very rewarding. My wife doesn't understand it at all. She says, you know, why do you want to put up with that sort of stuff? And I said, you know, I enjoy it. I enjoy the intellectual challenge of it. I enjoy, it's not gamesmanship, but the give and take you have with lawyers. I enjoy that. I can truthfully say that being a magistrate judge was the best job that I could have gotten for my personality, for what I enjoy doing. It was, you know, I looked forward every day to getting out of bed and going to work. I really did, and I wish that for anybody. If you can find the job that you look forward to getting out of bed to go to, then that's that's great. That's not a job. That's living at that point.
Well, I think that's a pretty good ending to that observation, and thank you, because this really makes part of our history project alive, and also these will be on the website, and people can look not only to find out more about you, but to think about the position of magistrate judge.
Well, thank you. I appreciate that, and I've really I've enjoyed being here, and it's a great job.
Oh, and we didn't say what you had done for Federal Magistrate Judge Association when you were a director.
I was the 11th Circuit director for actually for 4 years. I filled out part of a term of a director that was elevated to a district judgeship, and then had a 3-year term of my own. So I was. This was all back during the great attempt to get a pay raise. So I was in one of the 11th Circuit. I was the 11th Circuit's director, along with Billy Cassidy, who was the president. And so,
well, that was a good crew.
I was the lawsuit skeptic, you know. When the beer lawsuit came along, and then Tommy Miller was the magistrate judge representative of it, I just never thought that would go anywhere. I never thought. So I was the skeptic, and so for the record, thank you, Tommy Miller.
That's right.
Thank you. Y'all persuaded me.
He persevered.
Yeah.
Right.
Yeah.
Well, all right. Well, thank you
for
very
your
much.
Time.